Record News is brought to you weekly from the SPNN studios in St. Paul. Now, last week we were covering the Minnesota Supreme Court argument that was on the issue of the St. Paul Organized Trash Collection Ordinance. And of course, this has been the news for the last few months. It's been ongoing litigation, and of course it ended up there at the Minnesota Supreme Court. Now, last week we heard arguments from the city of St. Paul why their ordinance should not have to stand the test of the voters. And we, of course, did not have an opportunity to hear the arguments of the attorney who was representing the people and the charter of St. Paul. But we might get to some of his film footage this evening. However, in the meantime, as we predicted last week, the Supreme Court, because of the time constraints of whether or not this issue is going to be on the ballot this fall, they had to come up with a decision last week, and they did. We predicted that they would side on the side of the charter and on the side that the ordinance has to be put on the ballot to be voted on by the people of St. Paul with either a thumbs up or a thumbs down. Now, the court, because of the time constraints they had, their order basically just said, we've come to a decision that it has to be on the ballot, and they haven't come out with their memorandum of law that we can read and understand the rationale that they base their order upon. That's going to be coming out in the future. But suffice it to say, St. Paul City Council, they had a special meeting on Friday, the 23rd of August, to decide what that ballot language would be so that they could meet the deadline and get it on the ballot. Because lo and behold, that deadline was Friday, the 23rd. So we've got lots to talk about this evening, and to help me with the report is Mr. Greg Copeland, who's been following this issue for quite some time. Thank you, Mr. Copeland, for being here.
Hey, it's my pleasure.
And we have, as I should mention for our viewers out there, if you haven't been following this issue, part of the reason why this organized trash ordinance is of a big deal in St. Paul is because St. Paul is a charter city, and that means that it's like they have a municipal constitution. And under that constitution, that municipal constitution, that charter, the citizens and the residents of St. Paul have certain rights under that charter. And so when the city council decided to ignore a petition of the people and go forward with contracting their organized trash collection, that is what led up to this litigation. So we're going to get started. Well, first of all, Mr. Copeland, before we get started with our film footage, any preliminary remarks that you would like to make?
Sure. I think that the people need to focus on the matter at hand, and that is, in fact, the charter, as you've been talking about, Diana, because, frankly, the charter talks about the ordinance, and the ordinance was what the people signed petitions to bring before the court. It was not, as the city wants everybody to believe, the contract with the garbage haulers. That is something entirely outside the purview of what the court considered, because the people brought the motion through their action in court, winning at the district court level as we did with Judge Castro, and then the Supreme Court upholding our position that the over 6,000 petitions were verified, were certified.
Signatures on the petition,
on
right?
the petitions were certified by Joe Mansky at Ramsey County Elections, which the city contracts with. And so there really was no question but that this, according to the charter, should go right to the ballot. There was really no need for this whole court process, except, as you point out, and I'll say that the city council and the mayor jointly put the charter literally in the trash, and even after the decision, the mayor seems to insist that this contract is so sacred to him that he will raise taxes to cover the cost of garbage collection. Well, the reality is that this whole issue is now in the hands of the people, and the people want to have their choice back in their hands. They want to be able to make a decision for themselves as to who they want to pick up their trash and at what cost, because frankly, the first promise of the city was that they were going to reduce costs. The reality is that costs have approximately doubled. For the people with the largest can, $647.24 a year for all of your recycling, your trash, your local and state taxes, the Ramsey County tax, the property tax bill from the city. All of this stuff adds up, $647.24. Who out there couldn't find a better use for their money than sending it to the trash company?
And I think you're discussing the fact that the mayor of St. Paul continues to want to focus on the cost of this contract, that if they can't continue with the contract, that there's going to be all these costs associated either with the breach of the contract or that they're going to have to perform under the contract. This goes to an argument that we heard at the Minnesota Supreme Court level, is that in the contract there's something called force majeure, which is a clause that says if something happens that is out of the control of the parties that cause the contract not to be performable, that there isn't a breach. And you see, the city has no control over how the residents of St. Paul are going to vote. So as the attorney representing the people indicated, he thought that the force majeure clause is certainly a valid clause that the city could rely upon. And so all this talk about a breach of contract and how they're going to have to pay millions, not billions, oh my God, millions of dollars in order to comply with the contract, that they're really ignoring the fact that they have a fallback, which is they have out of their control how the people of St. Paul are going to vote. Now, of course, they're going to put great pressure on the people of St. Paul to encourage them and pressure them into feeling like they must vote in support of that ordinance, in support of that resolution, because otherwise all chaos will result. But all chaos will not result. What will result is that each household will get to decide themselves who they want to contract with, rather than have the government say, you must contract with one company, and by the way, you know what, we've taken it out of your hands. We're going to do the contracting for you. You don't even get to negotiate your own contract. So you see, that's really, I think, part of this conflict that we're going to hear now in the next few months.
It is a huge veneer of actually a false claim. And you've pointed it out exactly. There is no need for people to believe what the mayor is saying about, oh, we have to raise $27 million more in taxes to pay Waste Management and his other favorite company, Republic. You know, honestly, the mayor is working harder for the trash companies than he's working for the citizens of the city.
And I think it should be pointed out, not just the trash companies, the monopolies. That is really, I mean, because there's other trash companies that are part of this consortium, smaller little trash companies, the few that are left that haven't been gobbled up by the big monopolies. But in reality, what this does is it supports the big monopolies, and they're the ones who are putting the little guys out of business.
Yeah, the immediate consequence, the actual result of this forced mandatory garbage collection in St. Paul has been, over 10 businesses that were in the garbage businesses are no longer in business They were bought out by these, as you put, multinational corporations that are now, 3 companies, 4 companies away from actually owning all of the business in St. Paul. And frankly, I think that is something that kind of works in the people's favor. Some people would say, well, where's the competition going to come from? Well, people can go into business. Think about this, folks. If you want to go into a new business in St. Paul, you might want to think about organizing to pick up trash, because guess what? The big boys now have spent a ton of money trying to buy up the city trash collection business. And you know what? They're going to have to deal with the competition, because the folks that have there's all this capital invested, they're going to want to return, and they're going to have to get competitive, and they're going to have to compete in the marketplace of reality, because I think the people of St. Paul are not going to be trifled with, and they're not going to believe the mayor who says we have to pay $27 million to the garbage companies when we have quite the ability to dial a number and get a cheaper rate from either the newest businesses in St. Paul, or there's a guy named Tennis, I noticed, that picks up in Roseville. I was over in Roseville and noticed a lot of his carts. He used to do almost everything in Maplewood. There are people out there right now that'll be happy to be knocking on doors.
Well, and keep in mind, certainly one of the smaller haulers that was literally pushed out of Maplewood was Gene's Disposal. And Gene's Disposal, they're still in business. I know that they would love to have some more business. Gene's Disposal's been around for a long time. And up until Maplewood forced us to have organized trash collection, my trash hauler was Gene's. And probably I had them for 25 years because it was good service and it was good rates. And, they always did the job just right. So, I had no problems.
You're absolutely right. I've got a friend on my alley who's got a commercial property who's not under the mandatory collection. And he uses Gene's, so I see Gene's truck still going down the alley. Of course, he doesn't stop anywhere except at my friend's place out on Payne Avenue. But, competition is what keeps prices down, folks. If you don't believe it, and you live in St. Paul, tell me about how you're doing your internet service between Comcast and CenturyLink. 2 choices. Doesn't work so well. They kind of got us.
Well, now we have quite a bit of film footage from the half-hour meeting of the St. Paul City Council of August 23rd. Because as I indicated, they had the decision from the Minnesota Supreme Court, and so in order to comply and also get their resolution into Ramsey County so it could be put on the ballot, they had to have a meeting, and they had to do it darn quick, and they had to have that language. So let's take a look at our first clip as they introduce what's going on and introduce the deputy mayor.
Resolution 19-1401, directing the city clerk to notify the county auditor to place a referendum of ordinance ORD 18-39 on the November 5, 2019 ballot and approving the title and language for that question.
I think to begin, we'll invite Deputy Mayor Tincher up.
So this is a meeting of the St. Paul City Council. Now, when we show our film clips of the Maplewood City Council, for instance, or the Roseville City Council, or any other city council, the mayor is always there with the council. You'll notice that the mayor of St. Paul didn't even attend this meeting. Now, it may be that he isn't required to attend this meeting, but instead of coming there with this very important issue to be discussed, he sends the deputy mayor instead. What's up with that?
And additionally, Diana, he had a 2 o'clock press conference before this 4:30 Friday afternoon meeting, and I assure you, this city council does not usually meet at 4:30 on Friday. City councils, nobody's around on Fridays with the city council. Mm-hmm. And this mayor, went on and on and on with his little sideshow saying, well, we're going to raise taxes. And, he's used different figures. When the court originally said, Mayor, you can't throw the charter in the trash. You could have done this thing entirely differently. And Judge Castro said, you got to put it on a ballot. you know, he used a figure of $13 million. Now all of a sudden it's $27 million. So I'm just not sure how this mayor is calculating things. The entire contract period was for 5 years.
Those garbage cans have been getting too close together. They've been multiplying.
Oh, well, we have more plastic on the alleys than we've ever had. That's for sure.
Well, let's take a look at our next clip.
Yesterday, the Supreme Court ordered Ordinance 1839, establishing rules for the coordinated garbage collection, be put on the ballot for a citywide vote. As Mayor Carter noted in his remarks a short time ago to media and the general public, we were prepared for yesterday's outcome and took proactive steps to ensure we could comply with the court's order. Today's meeting has been scheduled to adopt a title and ballot language and send this to Ramsey County to formally place the question on the November 5th general election ballot. The adoption of a title and ballot language at this meeting is vital because today is the deadline to get it to Ramsey County in order to comply with the Supreme Court's order. The ballot language before you was developed by staff from the City Attorney's Office, Finance, Public Works, and the Mayor's Office.
So I thought it was important to include that clip so you could hear all the departments that were involved in putting together the language that's going to be on the ballot, because that is one of the most critical aspects at this point of the juncture, is what language will be on the ballot. Will it be confusing? Will it be clear and straightforward? Will it mislead the voter to vote yes when they really wanted to vote no? There's a lot of considerations that go into the language of a ballot question. And
the goals in drafting were first, to comply with the law, and second, to be as clear as possible so voters would understand their vote. While we have a decision of the Supreme Court to place this ordinance on the ballot, we don't yet have the court's reasoning. We don't yet know the court's position regarding the impact the vote on Ordinance 1839 may have on the city's contract with the haulers or trash collection in general. Thank you.
And there again, Mr. Copeland, just as you indicated, the city always keeps coming back to that contracting dilemma that they've put themselves into. And that yet there are other options, I think, available to the city when it comes to that contract. But again, they're using that as the big hammer to put out there to get voters to vote maybe in a way that isn't consistent with the way that they really want to vote.
Well, you know, I'm really entertained by Ms. Tincher because she's copying exactly what the mayor said. No surprise, she works for him. The reality is, though, that all this discussion about we don't know what the Supreme Court is going to say in their memorandum. Well, they don't, but let me give you a hint, and it's one sentence out of the city charter. And it says in our city charter, and this is in section 8.05 under referendums, it says the ordinance shall not become operative until a majority of those voting on the ordinance, this is the ordinance that's under consideration because the citizens signed petitions, over 6,000 signatures, we have to vote in favor in order for the ordinance to take effect. And the way the language was crafted by the city attorney, they mentioned all these other departments. I'm sure that the public works director wasn't doing the legal work, although you never know. But, you know, the reason it's there is because the charter prescribes it. The law, you can say, yes, but it's the charter. It's on the section here. It's so simple, so straightforward. Hey, you know, they could have read it months ago. We could have avoided the court costs at the district level. We could have avoided the Supreme Court. But, you know, every once in a while it's good to have these civic education experiences. And, of course, the court came into a special session. As you know, Diana, they don't generally hear these cases in August.
Right, because it's a period of time when they're not in session. So
Well,
they actually came and heard this out of their usual cycle.
Well, you know what Justice Lillehog did last year, Diana? He got the state Supreme Court members to take turns staffing a booth out at the state fair. I was out there working today. That's why I'm in my bibs here, where I work. But and so this is the kind of thing they do in August.
Well,
You know, they're
let's hear the additional discussions then as they start getting into talking about, well, what's going to be on the ballot.
Great. And so the Supreme Court ruled on this question yesterday. It ruled that it should go to the public as a referendum. And what is before us today is voting on the title and the ballot language.
Correct.
Great. Okay, thank you. Are there questions for Ms. Tincher? Okay, thank you very much.
Now, one thing about this particular meeting is that it was a special meeting, and as we get into the next clip, they're going to talk about what is different about a special meeting versus when they have their typical city council meeting. Let's take a look.
So we didn't notice this meeting as a public hearing, but I know that there may be people here who have comments on the ballot language that's before us. So before we go to the vote, I would like to put 15 minutes on the clock for community members who have feedback on the ballot language specifically. We do have a deadline to meet today at Ramsey County, so I am going to keep us on track. I'm going to keep us focused on the language itself so that we can get to our vote today. So unless there's objections from my colleagues, I would like to go to public comments and then back to council members for before we vote. That works? Great.
When I heard this part of the meeting, I was a little taken aback because generally what I've heard in many different city council meetings is that if there isn't a need to have a public hearing and open up the floor to resident comments, they just don't do it because they don't want to have to go through the suffering of hearing what the people of the community have to say. And so when I heard that this special meeting, even though there wasn't a public hearing in it, that it was being opened up for public comment, I thought that was rather refreshing, especially considering that this topic is a very heated topic, and you can imagine what people might have to say when they get up. Of course, she's looking for commentary, mostly having to do with the wording of the ballot question. But if you open up the floor to comments, you can't really, once you've opened it up, you really can't censor what people are going to say, because that's also not allowed under the law.
Yeah,
so once it's open, it's open.
That First Amendment, we really prize that amendment, I think, as citizens, and never shall we release that. But it's amazing, yes, that President Bremoen is getting religion, so to speak, here and embracing public comment when she, as per se, as you say, doesn't have to do it in this case. But, you know, given the behavior of the council to do everything in their power to silence the citizens and take away their vote. In fact, Greg Joseph, the attorney for the citizens, when he got up in front of the court, the first words out of his mouth, other than good afternoon or good morning, I'm trying to remember now, but he said, I'm here representing the disenfranchised citizens of St. Paul. Because frankly, that's exactly what we were until the court remedied the situation by restoring our charter. That is the great gain here. It's not all about the trash. Yes, we're all concerned about the cost of the service, the quality of the service, the failure of the way this program's been implemented. It's been a disaster. Everybody knows that. But to take away our charter on a garbage program, I mean, can you believe this? In 2019?
So the issue that you bring up is very valid. It's about the integrity of the charter and preserving the integrity of the charter, because if one time the charter can be thrown out the window, that means that another time it can be thrown out the window, and another time and another time. So you're correct in saying it's not just about the trash, it's just not about the garbage and the ability and the right of being able to contract on your own. It's about the integrity of the charter of St. Paul.
Exactly.
So let's continue then as they open up the public comment.
But right now, what is in front of us is, the title says, Referendum on Whether Ordinance, Ord 18-39 should remain in effect. The question says, should Ordinance 1839 entitled Residential Coordinated Collection remain in effect for residential trash collection in St. Paul? Ordinance 18-39 creates new rules for the collection and disposal of trash and payment of trash service and requires that certain residential dwellings have trash collected by a designated trash hauler. A yes vote is in favor of keeping Ordinance 18-39. A no vote is a vote to get rid of Ordinance 18-39.
So, Mr. Copeland, this gets right back to what you were talking about before in looking and reading Section 8.05 of the Charter, in that they need to have more people voting yes than voting no in order to be consistent with what the Charter requires, that you need to have the majority number of people voting in favor of the ordinance. So in other words, if you're not in favor of the ordinance, vote no, and if there's a majority of people who vote no, then you can go back to having your own choice of contracting with whoever you want to do your trash collection. And it doesn't mean that there won't be trash collection, because you still have to have trash collection of some kind. It just means that it won't be this organized collection that is mandated and organized and contracted by the city without any citizen involvement in the process.
Exactly right. I thought it was interesting, the last term that President Bremont used in referring to the ordinance was to get rid of it. It almost appeared as though, that's an apt word, because we do want to get rid of the trash. And on November 5th, people have the right now to vote to take out all the trash once and for all. And let's get back to more important things. Now that we have our charter well protected, thanks to the Supreme Court. Thank you, Judge Castro, as well. But seriously, it's a great civic moment for St. Paul. I was 12 years on the Charter Commission. Believe me, the charter's never gotten more play than it has in this episode, frankly.
Well, and I think it shows the people of St. Paul how important their charter is.
Right.
Because one of the statements made at the Minnesota Supreme Court arguments is that the St. Paul Charter, in many respects, is broader in its protections for the residents, the citizens' rights under the charter than other charters might be. And so it really is a very important document. Now let's go on to our next clip, where they're going to open up the public hearing now that she has indicated what the language is at this point.
There's two? Okay. And three? Okay.
My name is Mike Schuman. I own a house on Dayton Avenue. And the language I don't have a problem with, but I just want to
That's what
talk a little bit about why for the last year you guys have not addressed the fundamental questions and problems of this program. I mean, I'm so frustrated that we have come to this point.
Michael, we're talking about the language,
Well,
and that is it.
Nice and fine, but when are we?
Michael,
Okay, just to answer a question.
Michael,
when are we going to have a chance to talk about
I'm trying to
fixing the
answer that
program?
question.
Okay.
So please listen. We will need to look at our levy limit and how that relates to what's in front of us with this potential change with the ordinance. It is our intention to have a conversation about trash service at that time. Right now, we're talking about the ballot language and only the ballot language.
Let's talk about something really basic. If you have a fourplex, right now you need 4 containers. All right, why can't we get a simple change to the program so I can decide to have 2 big containers instead of 4 little ones? Just basic things like that. That's all we asked. That's why we got to this point, because you guys, from October 1st, you refused to deal with just basic common sense issues. All right, and then the whole question on why are we paying double to 2.5 times as much for garbage service as the same house in Maplewood, which also has municipal collection. I mean, we need to have that discussion, and you guys have basically ignored that for the last year and are apparently going to ignore that going down the path in the future. And we need to fix this program, whether this ballot initiative succeeds or not. You know, we're tired of litigating with the city on every single issue. You guys need to start talking to us, and we need to start resolving these issues without going to court. All right? That's all we're asking. How much money have you guys spent on fighting us on this and losing? I mean, it started with the right-of-way case, and there's more right-of-way cases coming down the road, and all you guys do is dig in and litigate and litigate and litigate, and every time you do that, you lose. All right? It's time to basically start talking to us and fixing the problems. All right? That's all we're asking. And, you know, let's not wait till the election. This should happen next week.
And yet we heard that they're going to wait until they talk about what the levy's going to be and the limits of the levy limits within what they've already passed for resolutions for their levy increase for the fall. And that goes, Mr. Copeland, to that whole issue again. How much of a contract can we afford, rather than saying, well, let us rely upon the force majeure clause in that contract. It was beyond our control how the people voted. We had no control over that. And quite frankly, I would argue that the more that they meddle in trying to manipulate the voters and what the vote will be that they've engaged in activities where maybe somebody might argue that they did have control over the voters and how they might vote because they invested so much money in trying to manipulate the vote. So I think they would be better off not being involved in any of that at all, because then they can clearly say that they have had no impact on how the voters voted.
Yeah, I think the, you know, I'll say this, you know, the positive approach to this is to talk about that charter. Because while the mayor wants to talk about his contract with the garbage boys, I want to talk about the People's Charter. And the People's Charter, you know, really, as Mr. Schuman just indicated, this is just one example, that whole right-of-way issue about downtown charges against churches and other nonprofits and businesses. You know, these are huge issues. There's other instances of this kind of thing going on in our city too. We're being charged a right-of-way fee on our water bills, $18 a year that appeared some.
No, I have a quick question.
Yeah.
These right-of-ways,
Yeah.
are these right-of-ways in the city's land, on the city's land, the city's right-of-way?
This is on the water charge is a maintenance fee. It's called a right-of-way maintenance fee that's on your water bill, and all the money, I mean, even the folks that are administering our regional water system, which Maplewood's part of, and Roosevelt, you know, all these other cities. I mean, none of that money is actually used in the water department. They sit it downtown. It's, you know, I mean, the water department is part of the municipal government. It's a part of the municipality. So they kind of do a little bit what they're told. And of course, there's several members of the city council that sit on that body as well. And so, you know, I think those dollars, if they're going to be spent, should be spent on things related, in fact, to the service that the customers are paying for, because those water bills are about the service,
And you
not
know what?
about collecting an additional bunch of tax money and calling it something else.
Perhaps one way that could be accomplished is that if they made it an enterprise fund, then those funds would have to be collected, they would have to be segregated, and they'd have to have a better accounting of what was being used for those funds and use them, as you indicated, for water line purposes.
Yeah, I think the regional utility does I think a pretty good job. I mean, they you know, they're looking out for future maintenance costs. They understand the age of the system that we have and those type of things, and those are realities that we're not going to get away from. But when they're basically told by the folks downtown, you know, you got to levy this fee, this right-of-way maintenance charge, because, and it's not money that they're using, I think that creates a heck of a problem. And one of my proposals has always been to use that money to help pay for eliminating the lead service lines that still exist in St. Paul. A lot of cities would love to help their residents pay for that. There are many of these old lines that are serving low-income parts of the city. We could take that money, and it's a lot of money over the years. They've been collecting this on the water belt. We could be spending it to match with some, perhaps some state or federal grants, or put something in place. I mean, our legislators, our congresswomen could get to work, and we could use this money to leverage other funds to replace these lead service lines, because I keep hearing about the city of Newark, where a certain presidential candidate is being accused of ignoring his job when he was the mayor. We also remember Flint, Michigan, with the problems there.
Absolutely.
So these are things we could be doing when we have lead in people's homes in Ramsey County. We try to help people deal with that problem because we don't want children getting brain damage.
And Mr. Copeland, that sounds like actually another whole show. We could really cover that in detail. That sounds like an excellent topic for a future. I'm sure our viewers would like to hear
I'm just
some
trying
more
to be
about
positive.
That. Yeah, that's right.
There you go.
But there was a couple people who spoke at the St. Paul City Council meeting of August 23rd. And so let's listen to the next resident who had a question and a comment.
Hi, my name is Charlotte Osborne, and I live in Ward 4 on Fulham Street. And I have just one question and then one comment. The question is, if somebody doesn't vote, how is that counted?
I will look to our city attorney. I will look to our city attorney's office for an answer to that question.
Under our city charter, Councilmember Brenmo and council members, under our city charter, only votes are counted. So
Okay.
if there is no vote at all, then that ballot is not part of the number
Okay.
of ballots that's considered.
Thank you.
It's good to know that it has to be either an affirmative, either thumbs up or thumbs down.
Right, and unlike our state constitution that requires a larger than majority percentage vote in terms of passing additions to our constitution, in St. Paul, as the charter says, we're looking for a simple majority. The action has to be by a majority vote in the affirmative for that ordinance to stand. If the people say no in the majority, then it goes down, it's done, it's over. And there's a rule in the charter too that says that the city council has to respect that for at least a year. They can't go back and say, well, we're gonna show them we're in charge. None of that nonsense is gonna be allowed, and politically that's absurd anyway. I think it's absurd, I'll say that. And hopefully, the mayor will understand what the public says when we vote no in the majority, and maybe he'll get some clarity on these fiscal issues. The problem is, to some extent, that the tax levy is not set till when?
But they've already...
December.
Right. Well, that's the final tax levy.
Yes.
That's correct. Because I think they've already taken a vote on what the cap is, correct?
They will have.
Okay. And so let's take a look at our next clip as they start talking about this. There's then another question.
And there's only one word that I'm requesting to be changed, and that is certain residential dwellings must have trash collection. I would prefer, certain indicates that it might not be a majority. I would prefer you have something else like most, or define, and you're the ones that would know more about that, but certain, I don't think, shows the extent to what this ordinance covers. Thank you.
Thank you very much. Be sure to sign in.
And this then causes quite a bit of discussion by the council members, because this one word describing the properties that are affected by the ordinance as saying certain properties. It doesn't necessarily say which properties. You would have to have read the ordinance to know which properties it is, because not all residential properties are affected by this ordinance. So for instance, high-density housing is not affected by this ordinance. Commercial properties, I don't believe, are affected by this ordinance.
That's correct.
So it's those residential units that are 1 to 4 units in a property that are affected, that are residential. So by saying those certain properties, it doesn't say what kind of certain properties. And this particular resident is saying, well, maybe that word should be substituted with the word many properties that are affected by it. Well, now let's listen to what that discussion is of the council members.
Appreciate that point and the point that our constituent raised as well. And I think the last thing that I want and that any of us around this table want is for there to be any concern that this question is framed in any way to weight one side or another. I think that has been my concern looking at it from the beginning. I know that is, and I appreciate the comments saying from those who are looking at this critically that it is objective. So that's what I want to leave today with, is feeling like this language is fair and balanced. And so I understand the concern that certain might make it seem like not very many. I would support something like many, that many residential dwellings or designated residential dwellings, although I could see how designated might still seem like just a few. But I do understand why the city attorney's office doesn't want to get into the details of the way that trash is collected, since that is not what's at issue. So.
Right, because many residential units in our city are multifamily housing units that this would not apply to as well. So it's a challenge to figure out what that number is.
Prior to these comments, Councilmember Jane Prince had talked about how prior to this meeting, she had that concern as well. And she had reached out to city staff to see whether or not, rather than having the word certain, if you could describe it as residential units 1, 2, 3, or 4. And that the staff basically told her that that just made the waters too muddy and really complicated things. And so she had that idea that perhaps that word wasn't the right word. And now you've heard this council member say, well, maybe we should have the word many instead of certain. But not all council members are on board with that. So let's take a look.
I would just say the one thing, and I think, many we could talk about why many might be objectionable to or anything like that. The one thing in the totality of that's been written by the city attorney to comply with everything, and the most important thing that I looked at when I read this was that it was short enough short enough not to be the entire ordinance, but able in plain language for people to understand. And I think I would be very nervous about playing with any of the language right now, because at first blush and at second blush and at third blush of reading this, I continue to think it meets that standard of being simple and plain to understand. And this will be translated as well.
Reading between the lines, basically he wants to rely upon what the city attorney came up with, because maybe if they change it somehow, they might open themselves up to more litigation. And I can certainly understand that, having just come out of the case and having lost the case, that they don't want to have additional litigation because of the language. So there is certainly a point to that. Let's find out what the next council member has to say.
Strikes me that we want to have language that is as factual as possible, and I feel like many is open to wide interpretation, and that certain is actually accurate to what is in the ordinance, and that the education effort for the resulting referendum is where folks can make meaning of it and talk about it. And so I guess I worry about kind of getting ahead of the question, and if we're trying to pass factual language, I feel like certain is vetted by our attorney, has consensus, and then folks can elevate what they want to. So I wouldn't necessarily hardcore object to many, but it strikes me that we have sufficient language to move forward.
Yeah, sure. I personally share your concern. I think many seems fine, but it does, again, as I said, what's many, when you live in a multifamily residential property, this doesn't apply to your trash service. So
Now, I can see where they want to use the word certain because as the council member Nelson indicated, it comes down to those education efforts before the election. Now, this is actually the first time in this council meeting that anybody brought that wrinkle up. Who's going to do the education efforts to inform the residents of St. Paul what the ballot question means? And who can do those education efforts? Well, certainly, there's that word certain, there is going to be on the part of the residents who are looking to get a majority vote of no, that they're going to have to get out there and they're going to have to talk to their neighbors and they're going to have to make sure that people have an understanding of what this ballot question is. Because on the other side will be those who support organized trash collection, and they will have their education efforts as well. So now we'll have then the competing education efforts of the two sides trying to get the vote.
Yes, and having fought in many school referendum elections, you know, it's amazing how the school system spends literally hundreds of thousands of dollars selling their position to the public.
And yet I don't think they're supposed to.
Well,
but they find other ways and other avenues to do it, though, don't they?
Well,
See?
they have some cover under law to actually call it education. Of course, it's all just objective information. And frankly, if you look at that ballot question that was up on the screen, Diana, you know, every line except for the last line was part of the sales pitch from the city. There were several lines to that thing. I didn't count them, but the last line was it for the no side. If you want to get rid of, you vote no. That's it. All the rest of that stuff was sales promotion for the vote yes group.
Well, let's take a look at our next clip.
When I look at this language, one of the first thing I look at as a English as a second language person is it simple enough where whether you're for or against the referendum, you can translate this to different languages. For example, in the Hmong language, it's expression too, not just the definition or the straight translation, but expression. And so the way that it's written, I feel that it will make it more simplified in expressing whether you're a yes or a no in other languages. So I think that's something that we should consider. And so I think certain it's much more easier to translate than many, because then you have to now create another expression to describe what that is. And so I think that's something that we should be mindful of.
Another word that could be substituted for certain would be specific, because it does designate or imply that there are a group of properties that maybe you got to go look somewhere else to figure out what those properties are. I could see where the word many, depending upon maybe what language you're interpreting it, how much and how many are many.
I think the ordinance, more than likely, and I haven't read it lately, but specifies exactly the single-family residences, the apartment buildings, not apartment buildings, the fourplex, the threeplex, and the duplex. Those are the buildings, folks. So making this out to be some Herculean task, I mean, lawyers are all about figuring out good words to communicate with, and I think it is a rather poor structure to use certain when you can be specific. Why not be specific? We're talking about an ordinance that has language in it that you could put in this question.
Well, in the end, the city council voted with the language that was proposed by the city staff, namely the city attorney.
That's a shock.
That's right. So they went after all that discussion, the little that there was, They went with the word certain rather than the word many. But let's take a look.
Ms. Naker.
Thank you. I really appreciate that point and had not thought about the need and how this might translate into different languages. And above all, I want it to be clear. So and again, it sounded like for the most part, folks were comfortable with this language. I wanted to just explore that point a little bit, but there's nothing factually wrong about certain. It is clear. And so I'm comfortable withdrawing my amendment.
All right, so that amendment has been withdrawn.
Okay, so it was withdrawn and they all vote aye. Now, we have a few minutes left of our program, so we're going to switch gears here and go back to the argument in front of the Minnesota Supreme Court. And we have a lot of film footage on this, and we're only going to be able to touch on a couple of things with the remainder of our program today. But there is another whole discussion that we'll get into eventually that has to do with what happens if this ballot question, if the voters say no, get rid of the ordinance, then what happens with the contract, what happens with the ordinance, what happens with trash collection in St. Paul. All of that was discussed by the justices and the attorneys doing their arguments. So before we, of course, like I said, we'll get to all of that in another show. But tonight we're going to start off with some film footage of the attorney, Mr. Joseph, who was supporting the efforts of the residents of St. Paul and supporting the Constitution. Let's take a look at a question that the judge had for him.
What do you do with opposing counsel's argument? Points to, the only authority, the only body with authority to act is the city council. The statute seems to be phrased like that, and I think there's a philosophical problem working in the background here. A lot of talk about the charter provisions, but state constitution doesn't provide any provision for municipalities. I mean, the state law controls this, and the legislature has authority here. This might, in fact, I've raised this concern. This might, in fact, raise some pretty serious concerns for other ways in which cities might seek to use these progressive era reforms. But the legislature can do that.
This harkens back to what we discussed last week, where there's this conflict between what controls, the statute created by the legislature or the city charter, which is the municipal constitution of the people in St. Paul. And so this is the question that is coming out of this, is that, okay, the statute doesn't address cities that have charters, so what happens? Well, let's hear the response of the attorney.
Your Honor, the legislature built in protections for cities, okay? In this statute, we have a 6-month waiting period, okay, that the city chose not to avail itself of. The 6-month waiting period between the time the ordinance is enacted and the time that organized collection becomes reality, okay, there's only one reason why that could have been there, and that's to allow charter cities and allow the electorate to pass their own legislation.
Counsel, that's assuming they chose to proceed under 4A.
That's right.
But the statute gives them an option. They don't have to proceed they don't have to proceed at all, but if they choose to proceed, they can either proceed under 4A, which has that provision in it, but they can also go the route that they took under D, essentially, C and D.
That's right. That's right.
So
Your Honor,
I mean, the legislature gave them the option of doing either one, so it seems to undercut that position.
That's right, Your Honor, but that's not the only protection. The charter affords protections as well. Okay, the charter provides that first the referendum has to be brought within 45 days. Okay, and the reason for that is we don't want something protracted and extensive that's going to undo exactly, we try to avoid this exact situation. The second protection in the charter, Your Honor, is that any ordinance that's passed by the city council has a 30-day delay before the ordinance becomes effective. So these things are put into place to avoid this scenario. It was the city's choice to use the expedited process. The subdivision used by St. Paul, to me, it seems clear that would be better used by a statutory city, where, yes, the only feedback that the voters have in a statutory city is the one public input hearing, which the council's free to ignore. But in a charter city, that's not the case.
Council,
As we've indicated in past shows, cities can be organized in many different ways, as charter cities, as Plan B cities, Plan A cities, or a combination of different variations between any of those. And as Attorney Joseph indicates, there is a provision that is more conducive to a city who's a charter city, that if they would have taken that option, there would have been that time delay to allow for the people of the community that if they wanted to bring something, that they could do so. Now let's hear the next comment.
And I have this concern also, is what if this thing is on the ballot and the morning after November, whatever, the day, election day, the city of St. Paul wakes up and they find we don't have organized collection, we don't have unorganized collection, what's going to happen to the trash? It's a very practical question with regards to the effect of this referendum. What's your answer?
Well, what's the answer there? Well, every city needs to comply with the state statutes with regard to responsible management of your waste. But it doesn't mean that you're required to have organized trash collection. Now, Attorney Joseph makes a comment that the city of St. Paul, when they decided to choose which option under the statute that they wanted to take with regard to implementing their ordinance, that they actually selected that provision that is more similar to the provision that a statutory city like Maplewood would implement rather than a charter city. So as we heard, there's one provision that is more conducive to what a charter city would use, or there's the other provision which is more conducive to what a statutory city like Maplewood would choose, because in Maplewood, the residents, they don't have the right of referendum or initiative because they don't have a charter. So, Mr. Copeland, any last comments in the last 30 seconds?
Sure. I think if the city administration, and it's in the hands of Mayor Melvin Carter, he is a strong mayor by our charter, and people often don't think of it that way, but that is what the charter provides. And, he's got to act in good faith with what the people decide. And as an administrator, he's got to pull together a plan, it would seem to me, to be put in place on November 6th.
Yes. Well, thank you, Mr. Copeland, for being here.
Glad to be here.
And viewers, thank you for tuning in to this episode of Off the Record News. We'll see you again next week. Bye-bye.